Madam Registrar, would you please commence the proceedings?
Thank you, Judge. The Caribbean Court of Justice, Appellate Jurisdiction. On appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, St. Lucia. Judgment delivery in the matter, LCCV number 3 of 2024, between Exquisite Homes Limited and Geest Industries Estate Limited. The members of the delivery panel are the Honorable Mr. Justice Anderson, presiding judge.
Good afternoon, Counsel.
The Honorable Madam Justice Rajnath Lee.
Good day to everyone.
The Honorable Mr. Justice Barrow.
Good day, all.
And the Honorable Madam Justice Anoniwu.
Good afternoon, everyone.
Counsel, you may now enter your appearances.
May it please Your Honor, Horace Fraser appears for the appellant in this matter.
Thank you, Mr. Fraser.
And Your Honors, Carol Gideon Clovis, holding papers for Miss Cynthia Hinkson Ula today.
Thank you. Yes, well, Counsel, we have arrived at a decision in this matter. It's a unanimous decision, which means that all of us here on the bench agreed, along with our brother, Mr. Justice Peter Jamadar, who unfortunately is not able to be with us this afternoon. The judgment was authored by our sister, Justice Chantel Anoniwu, and I will ask her to read a summary of the judgment. Judge?
Thank you, Justice Anderson. This summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. This is an appeal originating from St. Lucia from the decision of the Court of Appeal of the Eastern Caribbean Supreme Court. The respondent, Geest Industries Estate Limited, or Geest, contracted to sell to the appellant, Exquisite Homes Limited, Exquisite Homes, 52.6 acres of land registered as parcel 314. Before the completion date of the contract, the Crown compulsorily acquired Geest's lands, including parcel 314. This appeal concerns whether Geest committed a repudiatory breach of the contract prior to the Crown's acquisition of parcel 314. Geest first attempted to sell parcel 314 to Exquisite Homes through a contract executed in December 2013, the 2013 agreement. As that contract was not fulfilled by its completion date, Geest treated the contract as terminated. In March 2016, the government indicated its intention to purchase Geest's lands inclusive of parcel 314. In August 2018, Geest made a proposal to the government for acquisition of its lands and confirmed this proposal in January 2019. In March 2019, Geest was informed that Cabinet had approved the acquisition of all of its lands. On 27th June 2019, Geest entered into a second contract with Exquisite Homes for the sale of parcel 314, the 2019 agreement, which was carded for completion on 27th July 2019. Geest disputed the authority of its then managing director to execute this agreement on its behalf. On 8th July 2019, the Governor General issued a declaration for the compulsory acquisition of Geest's lands, which was first published in the Gazette on 16th July 2019. The second declaration was published on 22nd July 2019 before the completion date of the agreement. Geest subsequently returned to Exquisite Homes the deposit paid under the contract. Exquisite Homes brought a claim in the High Court for damages for breach of contract and unlawful interference with contractual relations. Exquisite Homes contended that Geest committed a repudiatory breach of the contract by inviting and negotiating with the government the compulsory acquisition of the land. The trial judge determined that the 2019 agreement had superseded the 2013 agreement, but had been frustrated by the government's acquisition of parcel 314 before the completion date. Having determined that the contract was frustrated, the judge considered to be moot the issue of whether Geest had committed a repudiatory breach of the contract. The Court of Appeal upheld the High Court's ruling that the 2019 agreement had been frustrated and found that Exquisite Homes had failed to show evidence of a repudiatory breach of the agreement by Geest. Exquisite Homes appealed to the Caribbean Court of Justice against the judgment of the Court of Appeal on two grounds, one of which was withdrawn at the hearing. Accordingly, the sole ground of appeal for this court's consideration was whether the Court of Appeal erred in finding no evidence of a repudiatory breach of the 2019 agreement by Geest prior to the government's acquisition of parcel 314. Exquisite Homes contended that the government's acquisition of parcel 314 was based on a private treaty resulting from negotiations with Geest and was not a compulsory acquisition on the government's motion. Exquisite Homes maintained that Geest's negotiations with the government concerning acquisition of the land and the Cabinet's approval of the acquisition prior to the execution of the 2019 agreement disabled Geest from performing its obligations under the agreement. Exquisite Homes also attempted to show evidence of Geest's refusal to honor its obligations under the 2019 agreement. In delivering the judgment of the court, Justice Ononu agreed with the Court of Appeal's finding that Exquisite Homes failed to provide evidence that Geest committed a breach of the 2019 agreement prior to the government's acquisition of parcel 314. In reviewing sections 3 and 6 of the Land Acquisition Act, the court noted that the compulsory acquisition procedure entails the Governor General making a declaration that the land should be acquired for a public purpose and the publication of this declaration in 2 issues of the Gazette, with the land vesting absolutely in the Crown after the second publication. Section 6 requires, as part of the compulsory acquisition procedure, negotiations between the government and landowner for the purchase of the land by voluntary agreement and specifies that such negotiations may commence before publication of the declaration. Section 3(4) of the Land Acquisition Act affirms the ability of the government to acquire land for a public purpose by means of a private treaty. As this method of acquisition is legally founded on a voluntary agreement between the parties, rather than the Land Acquisition Act, there is no need for a declaration by the Governor General as to the government's intention to acquire the land for a public purpose and the publication of that declaration in the Gazette. The court concluded that the evidence in this case demonstrated compulsory acquisition rather than acquisition by private treaty of parcel 314. The court found that Exquisite Homes had provided no evidence of an agreement between the government and Geest for acquisition of parcel 314. Instead, Exquisite Homes had referred to a sequence of events, all of which occurred before the execution of the 2019 agreement, which point to the negotiations between the government and Geest that are part of the compulsory acquisition procedure pursuant to Section 6 of the Land Acquisition Act. The court did not consider that any of the other evidence cited by Exquisite Homes could substantiate a repudiatory breach of the agreement by Geest. The court therefore dismissed the appeal and awarded to Geest the agreed costs of the appeal. This represents the court's summary of its judgment.
Thank you, Judge. Counsel, anything from you?
Not from me, Your Honor.
Thank you very much. Were you saying something, Mr. Fraser? Thank you very much. In that case, I think we can bring these proceedings to an end. Madam Registrar, please.
Thank you, honorable judges. Thank you to counsel and thank you to the CCJ staff. This matter now stands adjourned.